The ink on that sentence was barely dry. 35 years, handed down in a Collin County courtroom in McKinney, Texas, on June 9th, 2026. A 19-year-old convicted of murder looking at the back half of his life behind bars. And by the very next morning, before most of the country had even finished reading the headline, his legal team had already filed the paperwork to undo all of it. A notice of appeal, less than 24 hours after the verdict. That is how fast it moved. His attorney, Mike Howard, took it straight to the press. He said his team had officially notified the court that Karmelo Anthony is filing an appeal, that there are several important issues for the appellate courts to consider, and that an appeal is a right afforded every American. Several important issues. He didn't spell every one of them out, not yet. But if you watch this trial closely, you already know there's one specific argument buried in this case that legal experts have been circling since before the jury was even seen. Argument that has, in this exact state, overturned murder convictions before. We're going to get to that one, I promise you, but not yet. Quick question before we go deeper. Where in the country are you watching from right now? Drop your state in the comments. I always want to know how far this stuff travels, because here's what I need you to understand first. A lot of people hear the word appeal and their brain fills in the blanks all wrong. They picture a do-over, new jury, fresh start, everybody back to square one. That is not what this is. Not even close. A notice of appeal is a short document, a piece of paper, basically. All it says is, we intend to fight this in a higher court. That's step one, and it just happened. From here, the case climbs to the 5th District Court of Appeals, located in downtown Dallas. That court handles appeals out of Dallas County, Collin County, and a stack of surrounding metro counties. And the process it runs is slow, grinding, and unforgiving of impatience. Here's the sequence. Howard's team has to build a full written brief, a document laying out every legal argument they believe was decided wrong at trial. The prosecution then files their own brief, arguing the conviction was clean and should stand. Then the appellate judges review all of it. Sometimes they hold oral arguments, sometimes they don't even bother, and this takes months, sometimes years. And while the lawyers write and the judges read, Karmelo Anthony does not get to go home and wait. There's no bail during this. He was transferred into the Texas Department of Criminal Justice on June 10th, sent first to the state intake facility in Huntsville, the spot where every new inmate in Texas gets processed, classified, and assigned a number before being shipped to a permanent unit somewhere in the state. He could end up housed anywhere. A cell in the Panhandle, a unit down near the Gulf. Nobody knows yet. So that's the board. That's how the game is actually played. But none of that mechanical stuff is what his lawyers are really betting the whole thing on. The real weapon in this appeal is something that happened before a single witness ever took the stand. It happened during jury selection, and it has a name. It's called a Batson challenge. Stay with me, because this is the centerpiece. This is the thing. During jury selection, both sides, prosecution and defense, get a set number of what are called peremptory strikes. Think of them as free passes. You can use a peremptory strike to remove a potential juror without giving any reason at all. No explanation required. It's a normal, everyday part of picking a jury. But there's a rule, a hard one. It goes all the way back to the United States Supreme Court in 1986, a case called Batson v. Kentucky. The ruling was about as clear as the law ever gets. You cannot use those strikes to remove a juror simply because of their race. Do that, and you've violated the Constitution. Full stop. Now, here's what happened in this trial. When the dust settled on jury selection, the prosecution had used its final 3 peremptory strikes on the last 3 remaining black prospective jurors in the pool. All 3 gone. And when the box was finally filled, 12 jurors, 6 alternates, not one of them was black, not a single one. In a case this racially charged, involving a black defendant and a white victim, the people deciding his fate did not include one black juror. Mike Howard saw it unfolding in real time, and he stood up on the spot. He filed a formal Batson challenge right there in the courtroom, arguing directly to Judge John Roach Jr. that those 3 strikes accounted for 100% of the available African-American jurors in the strike zone, and that wiping them out, all of them, was racially motivated. The prosecution pushed back hard. They said race had nothing to do with it. Their explanation? The 3 women they struck worked as educators. And in a case involving high school students in a school-sponsored event, they argued educators might lean towards sympathy. So it wasn't about race, they said. It was about profession. Judge Roach accepted that. He denied the challenge. The all-white jury was seated, the trial rolled forward, and that one ruling, made by one judge on one morning in the middle of jury selection, may now turn out to be the single most important moment in this entire case. Here's why it carries so much weight on appeal. An SMU law professor named Anna Offit, who wasn't part of the trial but was tracking it closely, explained the reality of these challenges to a Dallas outlet. She pointed out that Batson challenges are rarely made and even more rarely successful at the trial level, because it's genuinely not that hard for a prosecutor to come up with a race-neutral reason for a strike on the spot. But then she said the thing that actually matters here. When an appellate court reviews a Batson claim, it asks a very specific question. It looks at whether prospective jurors of different races were asked the same questions, the same number of follow-ups, and whether similarly situated white jurors were kept on the panel while comparable black jurors got cut. Sit with that for a second. Were there white educators left on that jury? Were there white jurors who voiced views similar to the black jurors who got struck? Because if the answer is yes, and if the defense can prove it on paper through the jury selection transcript, then that tidy, it's about profession explanation starts looking in a whole lot less like a reason and a whole lot more like a cover story. So has this argument ever actually worked? Has anyone ever walked into an appeals court with a Batson claim and walked out with a conviction in pieces? Yeah, they have. And it's happened right here in Texas. There's a case called Blackman v. Texas. A jury convicted the defendant of felony drug possession with intent to deliver. The trial court hit him with 30 years. On appeal, his team argued the state had used a peremptory strike to remove a black prospective juror in violation of Batson. And the Court of Appeals agreed. They found that at least one of the prosecutors stated reasons for that strike was a pretext, a cover story that didn't hold up under scrutiny. They reversed the conviction, sent it back, gone. Then there's Miller L.V. Cockrell, a Texas death row case that climbed all the way to the United States Supreme Court, not once, but twice. Thomas Miller L. had been convicted of murder by an all-white jury after black prospective jurors were struck. He spent years fighting, and eventually the Supreme Court dug into the full record, the selection transcripts, the juror questionnaires, the strike patterns, and ruled that the peremptory strikes had violated Batson. His conviction was overturned. And then there's Foster v. Chapman out of Georgia. Prosecutors struck all 4 black prospective jurors, offered up race-neutral reasons, and the lower courts bought it. Foster was convicted. But years later, his team got their hands on the prosecution's own private jury selection notes. And those notes had ranked the black jurors against one another, highlighted them by race. It was written proof of racial intent, the kind of thing that almost never sees daylight. The Supreme Court reversed. Now, is Karmelo Anthony's situation as airtight as Foster, with a literal paper trail? Probably not. Is it as exhaustively documented as Miller L? We don't know yet. But here's what we do know, and it matters a lot. The defense preserved this challenge correctly at trial. They raised it in the moment, which means the full jury selection record, every question asked, every answer given, every strike made, is locked in. The appellate court can pull that transcript and compare the black prospective jurors to the white ones who were also educators, line by line, and hunt for inconsistencies. And if they find them, this conviction doesn't just get trimmed, it gets thrown out, and the whole thing starts over. If you're the kind of person who actually wants to understand how these cases turn, not just the verdict, but the machinery underneath it, do me a favor and hit that subscribe button and drop a like. This is the stuff that doesn't make the evening news, and following along now means you'll see exactly how it lands when the rulings start coming, because Batson isn't even the only card on the table. Here's something that's been gaining steam since the verdict dropped. Supporters of Karmelo Anthony aren't only talking about the jury. They're talking about an attorney named Christopher King, who identified himself as a supporter of the Anthony family, stood outside the courthouse on the evening of June 9th and called the verdict a travesty of justice. And he pointed specifically at the video evidence, saying the footage advocates had viewed did not match the testimony the jury heard at trial. Let's be precise about what's actually known here. During the trial, prosecutors played security camera footage from the stadium where this happened. They argued it showed Anthony entering the tent, a burst of rapid movement, and then Anthony leaving and running. To the state, that footage captured the confrontation itself. But the defense and the supporters have raised real questions about it. Was the footage clear enough to establish exactly what happened? Did it show who moved first? Did it actually capture the moment the other team made physical contact? Or did it only catch the aftermath? And that distinction is the entire ball game, because the self-defense argument lived or died on sequence. Who initiated the physical contact? If Anthony reached for that knife first, the state's whole theory holds. If the push came first and he reacted in about a second flat, you're looking at a far murkier call for any jury. Here's the catch. Appellate courts generally don't second guess how a jury read the evidence. That's the jury's job, and judges are extremely reluctant to step on it. But, and this is the narrow door, if the defense can argue the jury was shown evidence in a misleading way, or that the judge made a legal error in how that footage was admitted or explained, that opens a different lane entirely. This argument is harder than the Batson claim, but it's real and it's being made loudly. And there's one more thing pulling at this case from the outside. Another case, one that is about to follow this appeal everywhere it goes. Belton, Texas, a high school. A confrontation that turned deadly. A teenager, Caysen Allison, brought a knife to a fight he said he was warned about, and another teen, Jose Luis Ramirez Jr., ended up dead. Allison went to trial on a self-defense claim, and the jury found him not guilty of murder. Instead, they convicted him of criminally negligent homicide, a dramatically lesser charge. The exposure he faced? Up to 2 years. 2 years versus 35. So let's actually compare them, honestly, because The surface similarities are what's driving the conversation. Same state, Texas. Same core claim, self-defense. Same basic situation, a teenager with a knife in a confrontation where the other person made physical contact. And the same devastating outcome, a young person is dead. But the differences are where it gets uncomfortable. Caysen Allison took the stand. He looked at that jury and told them, in his own words, that he was terrified, that he'd warned the other kid, that he was attacked first. Karmelo Anthony did not testify. Allison's defense also had video that, by their account, clearly showed the other teen throwing the first punch. Documented, visible, hard to argue with. The footage in Anthony's case was disputed. And then there's the dimension nobody in that courtroom wanted to say out loud, but everybody outside it is thinking. Caysen Allison is white. Karmelo Anthony is black. Both sides in this trial told the jury flatly that race had nothing to do with any of it. And in a perfect system, a verdict rests on evidence and evidence alone. So let me put the question straight to you. When two cases line up this closely, same state, same claim, same tragic result, and the outcomes land 33 years apart, what do you do with that? Coincidence? Two different juries? Two different sets of facts? Or something harder to name? Because that comparison isn't going to sit quietly. It's going to ride shotgun with this appeal all the way to Dallas. So, what are the people who actually know this terrain saying? Former U.S. Attorney Cully Stimson went on national television the day after the verdict and laid out the potential grounds. He flagged the Batson claim as the most significant issue in play. He wasn't predicting a win. He was saying this is real legal ground, not noise, not wishful thinking from supporters. Professor Offit, who watched the selection happen live, kept circling back to that same specific inquiry, whether jurors of different races were questioned and treated the same way. That inquiry hasn't happened yet. It happens in Dallas. A community advocate named Bruce Carter framed it differently. He'd expected a manslaughter conviction and a sentence in the 10 to 15 year range, not 35. And he said something that's hard to argue with from any side. There were no winners here. None. The Collin County District Attorney, Greg Willis, said justice was served and stood firmly behind the verdict his office fought for. And the family of the young man who died, they aren't interested in appeals or legal theory. They buried a son. They want it over. And every new filing, every headline, every update drags them back into the worst day of their lives. That's a cost that never shows up in a single court document. So let's stop circling and name what could actually happen. There are 4 realistic roads from here. Road 1. The 5th District reviews everything, looks hard at the Batson issue, and affirms the conviction. It all stands. 35 years with parole eligibility after 17 and a half. And I have to be straight with you. Statistically, this is the most likely outcome. Appellate courts affirm the overwhelming majority of convictions they review. That's just the math. Road 2. The appellate court decides the Batson challenge was wrongly denied. They pull the selection record, compare those similarly situated jurors, and conclude the state's race-neutral reasons were pretextual. If that happens, the conviction isn't reduced, it's reversed. New trial, new jury, the whole thing back to the starting line. Road 3. They find a different legal error somewhere else. In how evidence was admitted, in the jury instructions, in how the self-defense charge was explained. Any meaningful legal mistake could be enough to send it back on its own. Road 4. The appeal fails at the 5th District, and the defense escalates to the Texas Court of Criminal Appeals, the highest criminal court in the state. And if a constitutional issue like Batson is genuinely in play, federal court can become the next stop after that. A road like that can stretch 3 years. 5. Miller L., the most famous Texas Batson case of them all, dragged on for more than a decade before the Supreme Court finally ruled. And Karmelo Anthony is 19. He has time in the worst possible sense of that word. So here's where this leaves us. The appeal is real. The legal ground is real. The Batson claim isn't some desperate Hail Mary invented by emotional supporters. It's a documented, preserved, on the record constitutional argument that has reversed convictions in this exact state more than once. Does that mean Anthony walks free? No, it does not. Does it mean the system failed? That's a harder question, and thoughtful, informed people are answering it in completely different ways right now. What it means is this. A 19-year-old is sitting in a Texas prison cell, assigned a number, waiting to find out whether a panel of judges in downtown Dallas will look at that jury box. 12 seats, not one black face, and ask the same question his attorney asked that morning. Were those last 3 jurors removed for their profession or for their race? That question now belongs to Dallas, and it could take years to answer. If you want to be there when it does, when the briefs land, when the court rules, when this either holds or comes apart at the seams, subscribe and stick around, because I'm following this one all the way to whatever the final word turns out to be. This case isn't closed. It just moved to a different courtroom. And the most important chapter hasn't been written yet.